This video is made possible by Practical Defense Systems, the best online security training at the lowest prices. You can start your security career today online at pdsclasses.com. Check them out. Hi, I'm Joel Persinger. I'm the Gun Guy. Thank you very much for all of your support of GunGuyTV. I'm super duper grateful for everything that you do. I had a great interview with Sam Paredes. We talked about the assault weapons ban in California, Judge Benitez throwing it out and declaring it unconstitutional. And Sam gave me some great insight about where he thinks that might go next. Also, we talked about, in great detail, we talked about the case itself and the decision itself, which both Sam and I have read entirely. It's a terrific decision, and you should read it. I'll put a link in the description for you. At the same time, we also talked about some things going on nationally with the Second Amendment, and we also talked about what's going on in California. Now, as a result, the interview is very long, so I'm not going to post the whole thing here because it would just be too long. So what I've done is broken it into two sections. The first section will be posted here on public formats, YouTube, BitChute, Rumble, and so on. And then the last half, the entire uncut interview, will appear as usual on Patreon for the GunGuyTV crew. So if you're not a member of the GunGuyTV crew, I urge you to join today. You can do that by going to GunGuyTVcrew.com, or you can follow the link in the description. Now let's get to the interview with Sam. Sam, thank you very much for coming on the show. I'm super grateful that you are here. Obviously, you know more about this stuff than I do, which is why you're here. And I'm just going to tag along for the ride. But I'm very grateful to you and also to Judge Benitez. He wrote a phenomenal decision. I've read it. You've read it. But I thought perhaps you might give us sort of a thumbnail sketch as to exactly what did he do in finding the California assault weapons ban unconstitutional.
Joel, it's always a pleasure to be with you. And before I discuss the decision in the Miller v. Becerra/Bonta case, you did a recent podcast where you encouraged supporters and believers in the Second Amendment that positive things are happening and that we will win. And now is not the time to get down in the dumps. And you were very encouraging. I listened to it while I was in the car, and I thought, oh man, that is awesome. And that was just before this case the decision was released by Judge Benitez. He's a federal district court judge from San Diego. He's the same one who ruled in our favor with regards to magazines and ammunition and those things. And now in this case, Miller v. Becerra, it's a case about California's Assault Weapons Control Act. And what he did, basically, the single most important takeaway is this: he declared the Assault Weapons Control Act of California as totally unconstitutional. And then he proceeded in the next 90-plus pages to detail by detail, step by step, eviscerate the rationale that was used to pass it, to maintain it, to amend it, to make it grow, to expand it. He carefully and with great detail took apart the issues that were brought up by the expert witnesses, the research that was submitted to the court. He carefully looked at all the research and said, when you are talking about the average private defender of their lives with a firearm, that they only need 2.2 rounds to defend themselves, hence no need for magazines and all of that stuff. He said, hey, wait a minute. You guys are monkeying with the numbers. You went out, first of all, there are no police records or government records to keep tabs of all of this stuff. So you went out and you got newspaper articles and tabulated that information based on the reports that you saw in newspapers. And then you included every occasion where a firearm was present but was not fired. So that automatically brings down the percent of, the number, the average number of rounds used in defense. So he did that across the board. Every piece of justification. The fact that, there's historical track record of this legislation in the state of California said, actually, before the act, there was no historical background, none whatsoever. So this is not a long-standing law, even though we've had it on the books now for quite some time, since 1989, but it doesn't qualify as under Justice Scalia's Heller versus Washington, D.C. when he mentioned that long-standing laws need to be considered, but that is not the case with this. So he smacked down the Attorney General, the researchers, the rationale of the state legislature, the faults that they had in coming to their conclusions, how irrational and illogical and untruthful all of the information was that they presented, and declared that, hey, listen, the primary test is whether a gun is popular in public use, according to Justice Scalia and Heller v. Washington, D.C. And then he pointed out the actual numbers of ARs and AKs that are sold in America, and it is plainly obvious that are in popular use. He went on to describe the fact that the AR-15 platform is probably the single best suited firearm platform to allow people of all shapes and sizes and strengths and ages to effectively and efficiently use a firearm to defend themselves in their home. You can change the size, you can change the weight, you can change the attributes, the sights, the grips, the handles. And then he went on to point out that there is, other than an appearance, there is no similarity between this and military firearms. And he did point out the fact that when they talk about assault weapons as being dangerous, he pointed out that all firearms are dangerous, actually, and that in over 80% of the cases, it isn't an assault weapon that's used, but it's a handgun that's used. And so this law really is not affecting a real problem when only 12% of all crimes across America and here in California occur with a long gun, and a semi-automatic firearms are a subset, a small percentage of that 12%. The fact of the matter is the numbers are infinitesimally small as to when a so-called assault weapon is used in the commission of a crime. It was a masterful job, and he knew that the government was going to have conniptions. They were going to have and be unable to withhold their urinary tracts in their pants, and they were going vehemently. The Attorney General and the governor obviously haven't read the whole decision, because all they did was jump on the fact that Judge Benitez likened an AR to a Swiss Army knife, one that can be configured in so many ways and can be used for so many purposes. He talked about the sporting use, the hunting use, the defense use, the defense of country, everything. And that is one platform. And he said, no wonder it's so popular. So, yeah, it was a thing of beauty.
You know, Sam, one thing you mentioned, and I apologize, you're breaking up a little bit, but we can still understand you. A little bit problem with the internet. So two things. One, first of all, thank you for the comment on the podcast. It is an interesting thing, and I suspect we'll see it here too. I think a lot of times gun owners are afraid of good news. Now, that sounds like a silly statement. It does. It sounds like a ridiculous statement, but it is reflective in subscriber counts. Every time I do anything that paints things in a positive light, I lose subscribers. I think I've lost almost 200 subscribers since posting the video version of that podcast.
Wow. And
it happens almost immediately. People will just unsubscribe because they don't want to hear good news. They want to hear people who are hyperbolic, and they want to hear people stirring up muck and so on. So if you're watching this, I would just urge you, it's okay. I would say it's okay to hear good news. Because there is good news in this fight. And it's not, I try not to be the hyperbolic guy. And I try not to be the guy who just stirs up fear and does fear mongering all the time, just for the purpose of building a YouTube channel. I'm not saying other people do that, but I think some do.
Mm-hmm.
But I do think it's an interesting thing, Sam, that it seems to me that gun owners are almost afraid to hear good news, and so they want to tune it out. They want to hear the guy who's upset or whatever. So I do lose subscribers every time. I'm not going to stop doing it because I think we need to hear good news, but it's an interesting thing that you brought that up. All right. Now, the other thing I think that's interesting, too, is this is the first time I've read a decision. Now, maybe it's happened before. It's the first time I've read a decision from a judge that went our way, wherein the judge used as part of the argument the militia argument, because so often the militia issue is used against us, and historically it has been used against us. And yet he said, no. You say these guns are suitable for military use. Well, good, because part of the right the Heller decision said that self-defense is the core of the right. But he explains in his decision that an ancillary part of that right is the fact that we have to be able to have the right to possess, own, carry, use firearms that are suitable and appropriate for militia use. I thought that was the most fantastic argument, because that was an argument in favor of firearms like AR-15s, civilian versions of AK-47s, and semi-automatic rifles and shotguns and handguns that could be used to defend the country. And even he mentioned defend the country not only against invaders, but also against tyrants. What are your thoughts?
You know, in describing that situation, the relationship between the core right of the Second Amendment and its relation to the orderly militia, he in essence took away the anti-gunners argument that the Second Amendment only relates to militia. He says, no, it does relate to the militia, but it also relates to all of these other things. So they have no more argument with regards to the militia. But you are absolutely right. If we are true believers in the Second Amendment, and we are called as law-abiding, able-bodied citizens to serve in the militia for whatever reason, our founding fathers wanted us to be able to go into our own closets, grab firearms, and stand with the Army equally armed, with arms that are useful and practical for accomplishing the mission, whatever that mission is. And so, yes, that was a beautiful thing that he kind of opened the door to say, well, maybe we need to look more into the attacks on military guns and private possession. That might be something that is looked into the future. But he kicked that door wide open, and then he was right. He read and defended the entire Second Amendment from the core all the way around and hit every issue. So yeah, it was marvelous. I haven't had goosebumps in succession as much in reading a judicial decision as I have in this 90-plus page ruling by Judge Benitez. This man is a true lover and believer in the Constitution. He knows what oppression is, and he knows what is required of free people in order to protect against tyranny and oppression. So, I mean, Senator Richardson, going to your earlier point, in his book, Confrontational Politics, he talks about the game of one downsmanship. Our folks, you talk to a group of gun owners who are standing around a table and having an adult beverage, and one of them comes up with a story. You know what happened with me and my guns, and somebody did a restraining order against me, or I lost my guns and I got them back, or I went to the range and I couldn't shoot. And the next guy says, well, you know what happened to me? I went out and took my Glock that never fails, and it failed. And then the next guy said, oh yeah, you know what happened to me? My guns melted in my gun safe. And then the next guy goes, well, I got one better than that. The BATF landed their black helicopter in my backyard and came in and confiscated all their guns. So how about that? And, you know, it's a game that we have to stop playing. We have to understand that we are involved and we are united in the fight to restore and protect the Second Amendment. We can achieve victories, and that is what we're doing now. So those who are naysayers and don't want to be involved, you know, all I say is enjoy your freedom and liberty, and we are going to stand here and protect your rights, whether you like it or not.
It's a funny thing that happens where we, and I don't mean to go down this philosophical rabbit hole too far, but I think it's instructive and it's illustrative to talk about it. It does seem that we go down these negative tracks a lot. Partly, I think that's driven by the media, by YouTube. And again, I'm not picking on YouTubers. So if you're a YouTuber and you think I'm picking on you, I'm not. I do think, however, that it's part of human nature to go down the path of the negative rather than focus on the positive. And there is negative out there, and I'm not saying that there isn't. We're not achieving perfect results, but to attack every win because it isn't perfect is foolish in the extreme. And I know people are going to be mad at me. In fact, frankly, I think it's childish. We're at a point where we have to realize as adults, we have to grow up, and we have to realize that we're not going to get a perfect answer every time. We lost our rights incrementally. We're going to get them back incrementally, which means each incremental win is a solid win, and it's something we should celebrate, not detract from, and not complain that it isn't exactly what we want. You know, I'm an old guy like you are, and I can tell you in life you don't get exactly what you want each time. You have to go fight the battle for it. So I'm encouraged by each and every win. I'm particularly encouraged by the fact that Judge Benitez got ahead of a lot of the things in this decision, and even if this decision is overturned by the Nutty Ninth, which we'll talk about here in just a second, the fact that he modeled how to write a decision in support of the Second Amendment, I think, was marvelous. One of the things that he did, in fact, if you have not read it, I will put a link in the description to the entire decision, and you should read it. It's 94 pages, but I'll tell you what, it's among the most encouraging 94 pages you're ever going to read if you're a gun owner. So I encourage you to read it, and he writes it in such a way that even the average person can easily understand the points that he's making. One thing he talked about was he used the testimony of a general who indicated that not only was militia use and a firearm for militia use important, but the AR-15 was ideal for militia use and should be owned by every able-bodied American, specifically for militia use, not to be held just for that, but as part of their Second Amendment right, in part because, as he pointed out, it can be adjusted like a Lego for each and every mission, and National Guard armorers, military armorers can take those guns that are brought by civilians for militia use and then repair them if they need to be repaired because the parts are interchangeable. They can make changes to it, set it up depending on what the mission specifics are. All of those things can be done to that civilian tool for that civilian's use for militia service. And that's what makes the AR-15 ideal for that. And as a result, it should not be banned. I have never seen that in a judicial support for the Second Amendment and for AR-15s or those types of rifles before. I was absolutely enthralled by it and incredibly encouraged by it. And so I do urge you, if you haven't already read it, it's a good read. You should sit down and read it. It is a most amazing decision with regard to the modern sporting rifle and its militia application as well as its self-defense application. I think I've ever seen.
Joel, I got a real chuckle when he challenged the Attorney General for criticizing the fact that they are that the attributes of the AR-15 platform make it easy to use and they are accurate, which is the argument that the government is saying is why we shouldn't have them around, because criminals can commit their crimes easier and more accurately. And you know, he pointed out, well, you know, if they weren't accurate, they might miss their primary targets, but they'll probably still hit somebody else, and it really doesn't matter. They're committing a crime. And the fact that as law-abiding and responsible citizens, we want firearms that are easy for us to use and that are accurate, so that when we need to use them, we use them well. We do what we need to do. We are responsible for every round that comes out of that muzzle. And we want to make sure that if we are shooting somebody who is committing some sort of evil that can cause somebody's a great bodily harm or death, we want to be able to accurately use these firearms. And the AR-15 platform, because of the attribute, he talked about forward pistol grips and adjustable stocks, how an elderly lady used an AR-15 to defend herself in a home, and how young people can use it and older people can use it, and big people and little people. And that is what makes the AR the single most popular platform in America right now, being purchased by the millions from hundreds of manufacturers that are concentrating on this platform. So yeah, I really got a chuckle when he said, "Oh, so you want law-abiding citizens to have an inaccurate gun, one that's hard to use." And then he pointed out that law-abiding citizens use firearms to defend themselves far more often than criminals use guns to commit mass shootings. It was truly, as I agree with you wholeheartedly, everybody needs to read it. It's written in clear and plain English. And obviously, Judge Benitez did his homework to describe the AR-15, what it's capable of. He talked about the 223 and from the beginning, and what its design was for, and just as an outgrowth, and why it was the weapon, the cartridge of choice, that it was not a high-powered round, but a medium-powered round that was more designed in the Vietnam era or as a wounding gun, he said. The philosophy was that if you wound more of the enemy is going to have to spend more time going and to retrieve their wounded comrades, and would therefore not be able to continue the fight. So he covered. I can't think of anything that he didn't cover, Joel.
I honestly can't either, Sam. I mean, it was the most thorough decision I think I've ever read. In fact, frankly, it really was. It was an apologetics class. I mean, if you've ever heard the term Christian apologetics, that's a way to defend Christianity if you're in a discussion with somebody who is telling you that it's not true. Well, this was Second Amendment apologetics. This was, and apologetics does not mean apologizing for something. So if I'm being confusing, I apologize. But this, speaking of apologetics, but this apologetics is the argument, the ability to effectively and articulate your argument and support your argument factually. This thing is an entire class on Second Amendment apologetics. It deals with each and every assault upon our rights, and he refutes them all. And he does it in such an incredibly eloquent, straightforward way that he makes the arguments against the ownership of modern sporting rifles, whatever you want to call them, seem as absurd as it is. He very clearly points out every absurdity in the California law and in laws like it. So that brings up an interesting question, because this decision is extraordinarily well written. And California took it on the chin big time with this one. They have a choice, Sam. They can try to appeal it, but the Ninth Circuit is not the nutty ninth like it used to be. And it's going to have to do some serious backbending, contortionist gymnastics to come up with a way to decide that this thing was incorrect. I don't know how they're going to do it, but they're going to look stupid if they do. If this thing ends up going to the Ninth Circuit and it is upheld, which is entirely likely, then it affects not just California, but all of the states that fall within the Ninth Circuit. If it is overturned in the Ninth and it goes to the Supreme Court, which is entirely possible, because now the left has to be looking at the Supreme Court and going, wait a minute, they're taking a Second Amendment case. They could take this one. How frightened are other states right now that this thing might be appealed and cause more trouble for them, not just California?
Joel, Justice Benitez was very thoughtful and forward-thinking in his decision and what he did. Now, his decision doesn't mean that we can go out and take our ARs and our AKs and take the bullet buttons off and reconfigure them back to standard operation, that we can get rid of our California compliant or featureless guns and turn them into regular ARs or AKs, because Judge Benitez actually issued a stay on this ruling and said that for 30 days this does not go into effect. And what effect means is, he said that the state of California and any and every law enforcement officer from federal down to local will not be able to charge or put into effect the Assault Weapons Control Act and any provisions of it. So they can't go after magazines, they can't go after configuration, they can't go after any of these things. But you can tell that he wasn't playing around by putting in this 30-day stay. Either the Attorney General does not appeal to the 9th within the 30 days, in which case at the 30th day, that becomes the law. The Assault Weapons Control Act vaporizes in California, and then we can convert our guns. If they do appeal it, it'll go to the 9th. I think the judge was concerned that he would be putting the 9th in a situation where they have to issue an emergency stay in order to stop the law from his ruling from going into effect until they reviewed the request for a stay from the Attorney General. And there's a whole lot of gymnastics. So he said, we're going to cut all that crap out. I'm going to give them 30 days to do it. That means they won't have to go through any emergency process. They can go through the regular process of appealing this thing. Now, remember that there is already an assault weapons case sitting in the 9th. It's called Rupp v. Becerra, that was filed by the California Rifle and Pistol Association and with the assistance of Gun Owners of California. It is already sitting there. I'm guessing, and I'm not a lawyer, but I have been watching the 9th for a long time. I'm guessing that they will probably take this Miller case and combine it with the Rupp case, since they deal with the same issue. And then what will happen is that the 9th might issue another 3-judge panel to begin the process of reviewing this case. But I think that they are going to wait as long as they can to see what the Supreme Court does with New York State Rifle and Pistol Association versus Corlett. They know that the Supreme Court has taken that case, that they're going to hear it at the beginning of the next session, that's this fall, that they will issue a ruling at the end of spring of next year. And if they address the issue of the level of scrutiny that can be used on Second Amendment cases, it is going to govern how the 9th is going to be able to rule on this case and all of the other gun control cases that are in their dockets. So, yes, to directly answer your question, that's kind of the long way around the barn. All of the other states in the 9th, including Hawaii and Washington, Oregon, California, Arizona, Nevada. A lot of the states are already free and they don't have these issues, but a lot of them do. And yeah, they're going to be concerned that they're wetting their pants, that people are going to be able to buy any AR-15 they want and convert it any way to any configuration they want in order to defend themselves in their homes and for all other legal purposes. He pointed that out. You can have that gun for all legal purposes, and then he enumerated what those included. And it was everything, from the militia to self-defense, to hunting, to target shooting, to collecting, defense in the home, all of those things. So I think that this is a huge victory. And the odds are that if they do issue a 3-judge panel, it's going to be one that we have a chance of winning. And then they're going to have the conundrum of, okay, do we do an en banc in order to overturn a good ruling from a 3-judge panel like they have in all of the other cases? And you're right. how are they going to take? They're going to have to totally ignore everything that Judge Benitez wrote in order to justify that the Assault Weapons Control Act of California is valid and legal and constitutional. So we are in for some very interesting times within the next year.
Thank you very much for watching the interview here. This is as much as I can get into YouTube and the other public formats without it being just so long that even the YouTube algorithm won't like it, and you'd never see it posted anywhere or even suggested. So as a result, the rest of the interview, the full interview from start to finish uncut, is going to appear on the GunGuyTV crew, and that's for our crew members on Patreon. If you'd like to go watch it, I urge you to join the crew. You can join by going to GunGuyTVcrew.com, or you can just look at the link in the description. That's where you'll find the full interview. Now, the other thing we do for the crew is we always do complete uncut interviews over there and post them so that you can always see the detail in case we had to trim something down. We also do the full podcast instead of just the first half hour. I've got some live streams coming up. I post pretty much every day. Something gets posted over there, Monday through Friday, that's of interest. And so I do urge you to check it out. It's at GunGuyTVcrew.com, or like I said, you can follow the link in the description. Thank you again for watching. Have a wonderful week, and wherever you go, whatever you do, be safe.